Hello learners, in this video we will be dealing with the Design Act 2000. Myself Swati Singh, lawyer, patent and trademark attorney. When a company or a person has made an article, some distinct design, definitely they want protection. The Design Act of 1911 has been replaced with the Design Act of 2000 in order to align with the international standards. And what design is has been defined under Section 2D of the Design Act. What design means? It means only features of shape, configuration, pattern, ornament, or composition of lines or colors applied to an article. Whether it's two-dimensional or three-dimensional, it doesn't matter. Or it has been prepared, it has been made involving any industrial process, or manually it has been made, or through mechanical process or chemical process, separately or in combination, it doesn't matter. But it should be of unique, distinct appearance, very appealing to the eyes. But it should not be any trademark. It should not be any copyrighted design. It should not be any property mark. So by making simple variations that you cannot claim for design patent under this act. In definition of design, we find certain explicit exclusions like construction methods, mechanical devices, like for considering a design for protection under this act, the functional aspects or construction principles involved in that will not be considered. Functional mechanisms will not be considered. What will be considered will be the visual appearance. Trademarks, property marks, which already have got protection under separate legal frameworks will not be considered under this Design Act. Similarly, artistic works which are given protection under copyright law will not be considered under this act. They will be excluded. So, claiming a protection for a design, it should be applied to an article. But what an article is? The Act defines under Section 2A what an article means. It means an object to which a design is applied, and it should be appealing to the eye. And the article should be an article of manufacture, that it should be capable of being manufactured in an industry, and any substance, be it artificial or partly artificial and partly natural, not completely natural. It should be and is there, partly artificial and partly natural. And it includes any part of the article subject to the condition it is capable of being made and sold separately. Let us discuss the key elements of the definition of article. First, it should be an article of manufacture. It involves a wide range of products that are made through industrial processes and includes both simple items and complex goods, reflecting the diversity of manufactured products available in the market. Second element is substance. It should be substance. In what substance? Which includes, it refers to materials that can be either be raw, that substance can be raw or processed. Either it can be. So both the final product and the raw materials falls under the definition of article. Then it should be artificial and natural and is used, so it should be both. The inclusion of both artificial and partly natural substances recognizes spectrum of materials. And under artificial, we can consider the man-made materials. And under partly artificial and partly natural, both natural materials and man-made components will be involved, which should be taken into account together. Then another element is it can include any part of an article also. This clause expands definition to not only entire product but also the components. but subject to the condition that it should be manufactured and sold separately. For example, a chair may consist of various parts like legs, seats, backrest, but each of which can be made and sold separately. Overall, the definition of article is designed to encompass a wide variety of manufactured goods and their components, ensuring that the legal framework surrounding design protection is flexible and comprehensive enough to adapt to the evolving manufacturing processes and market needs. This broad scope ultimately supports creativity and innovation across various industries. The Design Act of 2000 originated in British era, had its roots in several earlier laws. Starting from 1859, we had first an act to protect the industrial design, then the first legislation we had, then it was consolidated and amended. Finally, taking inspiration for the British Act, Patent and Design Act, we had the Patent and Design Act of 1911. In 1970, Patent Act repealed the patent provisions of the 1911 Design Act. What all patent provisions were there in the Indian Patent and Design Act of 1911, those patent provisions were repealed. In 2000, the Design Act came into force on May 11, 2001. Included most of the provisions of 1911, plus some changes relating to international conventions to which India was signatory. Under the Act of 2000, Locarno classification has been adopted, in which classification is based only on the subject matter of the design. The Design Act 2000 is based on the principle of first to file, first to get. This means that inventors and developers should file a registration application as soon as possible to prevent others from claiming rights to the design. Objective. What is the objective? The Act aims to protect the aesthetic aspects of a product, focusing on its design rather than its function. This encourages innovation and creativity in various industries. What is the significance of this? The introduction of Design Act has significantly enhanced the legal framework for protecting industrial designs in India, promoting innovation and safeguarding the interest of designers and manufacturers. Once your design get protected, design get registered, you get protection under the Act. So, the Act provides a framework for the registration of designs with the Controller General of Patent, Design and Trademarks. Registered designs receive legal protection, preventing unauthorized copying or use. Conditional provisions. The designs which were protected under the previous Design Act of 1911 continue to be protected under the new Act also. Protection of unregistered design. Can an unregistered design claim for a protection? Yes. While the Act primarily focuses on registered designs, it also recognizes that some unregistered designs may still be protected under common law principles. If you have been using any design for quite long time and it has become an symbol, like it identity for you, then definitely you can claim for protection under common law, but not under the Design Act. Even after getting registered your design, the registration can be cancelled anytime after the registration. An application for cancellation is admissible on the following grounds. The grounds on which the cancellation is possible is that a design has been previously registered in India. Second, it has been published in India or in any other country prior to the date of registration. That the design is not a new or original design, or the design is not registrable under this Act, or it is not a design as defined under Section 2D of the Act. For claiming protection under the Design Act, a design should fulfill certain criteria. They are, the design must be rather new or original, significantly distinguishable from known designs or combination of known designs. It should not be mere combination of known designs. It should be something which is distinct, which is different from the visual appearance. It should be different. It should be applied, it must be applied to an article and should be appealing to the eyes, not previously published in India or elsewhere, not solely functional or based on common shape, not comprise or contain scandalous or obscene matter, not be contrary to public order or morality, not be prejudicial to the security of India. If in exam you are asked to write exceptions or exclusions of designs which cannot be registered, so from the definition of design, an article, you can jot down some points like certain designs which are excluded from registration. They are designs which are primarily functional or based on a common shape, design that comprises or contains scandalous or obscene matter, design that is contrary to public order or morality, design that is prejudicial to the security of India. We just saw definitions in the last slide that on what grounds it can be cancelled. So you can put those grounds on which the grounds of exclusions, designs that are excluded from registration are, which if they fall under these categories. Designs that are primarily literary or artistic character are not protected under the Design Act. These will include books, calendars, labels, tokens, any principal modes of construction of an article, mere mechanical contrivance, any building or structure, parts of articles that cannot be manufactured or sold separately. If it can be sold or manufactured separately, then they can be protected. They cannot be excluded. Mere workshop alterations of components of an assembly. Once the design is protected, once the design gets registered, it gets protection for a period of 10 years, which can be extended for an additional 5 years. The date of registration will be the date on which the application for registration has been filed. Once your design gets registered, you get protection. So if any third person copies your design, you can take legal action against them. If an infringement is there, you can file a suit against them. And the remedies include injunctions and monetary damages. Like patent rights, design rights are also territorial in nature. They are granted on a country by country basis. If you have applied for design registration date, you have filed a design application in India for registration, and if it is registered, you'll be getting protection in India only, not in any other country. There is no system as yet wherein a single design application is sufficient to protect the design right internationally. However, the Paris Convention provides certain privileges to member countries in design registration. India is also a member country. If a person has filed for protection of design in India, then being a member of the convention, he can, within a period of 6 months, he can file in any other territory claiming for the protection, and it will take priority from the application which he has filed in India. If such a design is accepted for registration, it will be deemed to have registered from the same date on which the application is made in the home country. If he has made an application within that window of 6 months, but it will be counted as if, it will be treated as if that person has filed the application in other country on the same date on which he has filed application in home country India. The date will be same because The protection will be given for 10 years, and that 10 years starts from the period, from the date on which the application is filed. Irrespective of the country, the first application, wherever the person, he is claiming priority, that date of filing will be considered for counting the period of 10 years of protection. Steps to file an application for industrial design. Step 1. First step is to find whether any registration for your design already exists or not, whether the design is new or not. Before filing an application, applicant can also obtain information whether the design has already been registered or not by filing a request on Form 7. Depending whether if the research report is given and it is said that it has already been registered, then better you don't apply. But it is like that it has not been registered, design is new, then you can proceed with the second step, that is preparing a representation of the design on white A4 size paper. All the specifications are mentioned under the rules, how the representation has to be. Then is the third step of identifying the class. You have to identify the correct class under which your design falls. Under the third schedule of the Indian Design Act, you will find classification of goods. Almost all jurisdictions, including India, follow Locarno classification for registration of design, comprising 32 classes numbered 1 to 31, and an additional class 99 to include articles not falling under the aforesaid 31 classes. If your article is something which doesn't fall under any of the classes mentioned from 1 to 31, then you have to keep your article under class 99. Most of the classes are further divided into subclasses to give better clarification. Step 4 is to determine the fees, how much is to be paid. Step 5 is ensuring all enclosures are attached and due fee is paid to the concerned office. Applications can be filed either the design office in Calcutta, Kolkata, or branch offices of the patent office in Delhi, Mumbai, or Chennai. Designs registered come into force from the date of registration. The designs office initially provides a filing number and a filing date and issues a filing receipt, which is sent to the applicant or his attorney. Thereafter, the application is formally examined by the design office. Defects will be communicated to the applicant. He may answer if any queries are raised. Accordingly, if all the queries are answered and all the defects have been removed, finally the design will be registered.